makes Article 19(1) inapplicable. There is no reason TRJ suppose that for determination of the Aminer OD the Principialcies laid duvan in the law, any such procedure will be provided which will be unreasonable or opposed to the rules of natural justice, Pu 91-292. Section 3 of Constitution. 25th Amendment is unconstitutional and invalid. The validity of Section 3 of the 25th Amendment cannot be sustained because the said article suffers from two vices. The first is that it enables abrogation of the basic clements of the Constitution, inasmuch as the fundamental rights contained in Articles 14, 19, and 31 can be completely taken away. And, secondly, the power of A1NNDMCNT contained in Article 368 is of a special nature which has been exclusively conferred on Parliament, and can be exercised only in the manner laid down that article. The same could not be delegated to any other legislature in the country. Section 3 must therefore be declared to be unconstitutional and invalid, Pu 292J. The 29th Amendment is valid T&E question, whether the articles included in the 9th Schedule by that amendment, or any provision of those act abrogates any of the basic elements of die constitutional structure, or denudes them of their identity will have to be examined when the validity of those acts comes up for consideration. Hegde and Mukherjee, Ogyo. Kesavananda Dalala Yevj 25 a higher source, and which can and ought to be regarded as invalid when it comes in conflict with higher law. It cannot possibly include a law which the recipient is self-validating and which is never invalid. The distinction in constituent and legislative power is brought out by the feature in R1G1D Constitution that the amendment is by a different procedure than that by which ordinary law may be altered. The amending power is therefore said to be a recreation of THC Constituent Assembly every time Parliament amends the Constitution in accordance with Article 368, Ped 64, 365374. View contra in Golaknath First. State of Punjab, 1967. 2 SCR 6172, held incorrect Macaulay v. King, 1920, AC 691, and Bribery Commissioner Veer, Pitterick Ramwingi, 1965, AC 172, held inapplicable. Article 368 in the unamended form contains power as well J as self-execute J and G procedures, which if followed by the P described authorities, would result in an 11 Memon on 1 dement of the Constitution. The power to amend meant the F-Jower to adulter or reprol any provision of the Constitution. The power is unlimited, so long die the realt is an amended Constitution, that is to say, an organic interflernant which one vidies for the making, interpretation, and implementation of jaw. Under Proviso 2 to the unamended article, the power of amendment could be in Creo. Said there are no express or implied limitations on the power of amendment. There is no distinction between essential and non-essential features of the Constitution to raise any impediment to the exercise of the power of amendment. The preamble does not operate as a limitation on Th1 power of amendment. Odd amendment is a form of growth of the Constitution, and the term for amendment connotes definite and formal processes of constitutional change. These processes of change are the evolution of the Constitution. The force of tradition and custom and judicial interpretation may all affect the organic structure of the state. The object of amendment is to sect that the Constitution is perved. Rebellion or revolution is an illegal channel of giving expression to change. The consent of the governed is that each generation has a right to establish its own law. The people expressed in the preamble gave the Constitution, including the power to amend the Constitution, to the bodies mentioned in Article 368. These bodies represent the people. If a constitution provides the method of amendment, that method alone is one egal. Any method other than the method provided in Article 368, as for example, convening constituent assembly or referendum, would be revolutionary. Article 368 restricts only the procedure or the manner and form required for amendment, but not the kind or character of the amendment that may be made, the deliberative and restrictive process. And one procedure, ensure a change, the institution in an orderly fashion, one in order to give expression to social necessity, and to give permanence to the Constitution, 374, 319-2, Thex PR. See on amendment of this Constitution has a clear substantive McCann Wangwanan T, ontsext of a written constitution, and it means that any art of constitution can be amended by changing the sam or by variation, add one tion or repeal. The words for amend mcnta of this constitution may be initiated, and the words one the constitution shall stand amended in accordance with the terms of the bill in Article 368 indicate that the word 26 Supreme Court Reports 1973 Su PVSCR amendment is used in an unambiguous and clear manner.